The Supreme Court decision in the case of Arnold Navales and others versus People of the Philippines. Jurisprudence has laid down the following elements to sustain a conviction under Section 3, Paragraph E of Republic Act 3019 of the Anti-Graft and Corrupt Practices Act. 1. The offender is a public officer discharging official, administrative, or judicial functions. 2. He or she acted with manifest partiality, evident bad faith, or gross inexcusable negligence. And 3. In the discharge of functions, his or her action caused undue injury to any party, including the government, or gave any unwarranted benefits, advantage, or preference. A judicious review of the case records reveals that while the prosecution established the first element, namely, that petitioners were public officers of the DCWD performing official functions, it failed to prove the presence of the second and third elements beyond reasonable doubt. The second element refers to the modes by which the offense may be committed, namely, manifest partiality, evident bad faith, and gross inexcusable negligence, which case law defines as follows. There is manifest partiality when there is clear, notorious, or plain inclination or predilection to favor one side or person rather than another. Evident bad faith connotes not only bad judgment, but also palpably and patently fraudulent and dishonest purpose to do moral obliquity or conscious wrongdoing for some perverse motive or ill will. Evident bad faith contemplates a state of mind affirmatively operating with furtive design or with some motive of self-interest or ill will or for ulterior purposes. Gross inexcusable negligence refers to negligence characterized by the want of even the slightest care, acting or omitting to act in a situation where there is a duty to act, not inadvertently, but willfully and intentionally, with conscious indifference to consequences insofar as other persons may be affected. The amended information charged petitioners under the modes of evident bad faith and manifest partiality. According to the Sandigan Bayan, this was successfully proven by the prosecution for the acts of petitioners were in violation of Section 4 of Presidential Decree No. 1594, the prevailing law at the time of the incident. Essentially, the provision requires competitive public bidding for construction projects subject to certain exceptions where negotiated contracts are permitted. In particular, the Sandigan Bayan found that petitioners awarded the project to Hydroc without the required public bidding or the detailed engineering prior to bidding. They also failed to substantiate their claims that the lack of public bidding was justified under Section 4 of Presidential Decree No. 1594, specifically that there was an urgency and failure of competitive bidding due to poor participation in previous bidding invitations. They even allowed Hydroc to begin working on the VES 21 project even before the issuance of the Notice of Award and Notice to Proceed. At the outset, it must be clarified that petitioners Navales, Chavez, and Guillen, as members of the PBACB, merely recommended to the DCWD board the award of the contract to Hydroc. In fact, petitioners Almani and Lade were not even members of the PBACB. As this court found in GR numbers 194,763-64, it was the DCWD board which had the authority to approve and had in fact ultimately awarded the contract to Hydroc. But even granting that petitioners were primarily responsible for the same, prevailing jurisprudential pronouncements warrant their acquittal. In Martel versus People, the court stressed that a violation of a procurement law does not ipso facto lead to a violation of Section 3 paragraph E of Republic Act No. 3019. To successfully prosecute an accused under said section, it is imperative for the prosecution to prove beyond reasonable doubt that the accused violated the procurement law through evident bad faith, manifest partiality, or gross inexcusable negligence, thereby causing undue injury to any party, including the government, or giving any private party unwarranted benefits, advantage, or preference. A thorough review of the case records shows that the Sandy Gone buy-in convicted petitioners simply for their non-compliance with the procedure required by the law on procurement. Martel is emphatic. There can be no conviction under Section 3 paragraph E based on such fact alone. While there might have been irregularities in the procurement process that constituted as violations of procurement laws, there was no evidence to prove that petitioners were especially motivated by manifest partiality or evident bad faith. On the contrary, petitioners assert their honest belief that their resort to negotiated contract was permitted for being among the recognized exceptions under the law. Recall that Section 4 of Presidential Decree No. 1594 states that projects may be undertaken by negotiated contract only in exceptional cases where time is of the essence, or where there is lack of qualified bidders or contractors, or where there is a conclusive evidence that greater economy and efficiency would be achieved through this arrangement. First, petitioners stress that there was poor participation of well drillers in bidding invitations for well drilling projects. Second, there was a public outcry for water in the affected area, with residents resorting to street demonstrations. According to petitioners, Davos City was facing a water crisis at the time they passed the question resolutions. It bears stressing that evident bad faith partakes of the nature of fraud and does not simply denote bad judgment or negligence. It contemplates a patently dishonest purpose or perverse motive to do moral obliquity. In a similar manner, manifest partiality is in the nature of dolo and requires a malicious and deliberate inclination or predilection to favor one side or person rather than the other. Indeed, even as it turned out that the exceptional circumstances of urgency and failure of competitive bidding relied on by petitioners were not substantiated, Martel teaches that proof of their non-compliance with procurement laws, without further showing a malicious intent, cannot convict them of graft and corruption. Settled is the rule that mistakes, no matter how patently clear, are not actionable without any indication that these were committed with malice or gross negligence amounting to bad faith. The second element is, therefore, absent in this case. While the prosecution presented evidence to demonstrate certain procedural lapses in the procurement process, the same does not constitute proof of evident bad faith or manifest partiality on the part of petitioners. To the court, their failure to conduct competitive public bidding was driven not by an evil or corrupt motive, but by an honest, albeit mistaken, notion that a negotiated contract was permissible under the circumstances. As for the third element, the court finds that the same is also absent. Case law identifies the two ways by which Section 3 paragraph of Republic Act No. 3019 may be committed, namely, A. Causing undue injury to any party, including the government, or B. Giving any private party any unwarranted benefit, advantage, or preference. Applying the foregoing definitions, the court finds that the third element was not proven beyond reasonable doubt. To begin with, petitioners merely recommended to the DCWD board that the contract be awarded to Hydrock. It was the board which possessed the power to actually award the same. Moreover, as the court found in GR numbers 194,763-64, it was Carbonquillo who was predisposed to award the project to Hydrox sans the benefit of any bidding. This is clear from the tenor of his letter to DCWD's board of directors, already recommending direct negotiation of the project to Hydrox. But despite this express recommendation, and to the credit of petitioners, Carbonquillo's recommendation was disregarded, and the PBACB proceeded to invite other accredited well drillers. There were, in fact, 3 other companies that submitted their bids for the project. They lost, however, to Hydrox as they gave higher price quotations and sought later commencement dates. Settled is the rule that mere allegations are not proof beyond reasonable doubt, for to hold otherwise would be to permit mere speculations to qualify as proof of guilt. Verily, petitioners cannot be guilty under the third element, as there is reasonable doubt that they intentionally gave Hydrox unwarranted benefit, advantage, or preference. Indeed, it is Hornbook principle that to convict an accused in criminal prosecutions, the prosecution bears the burden to prove all the elements of the crime beyond reasonable doubt. In this case, the court finds that the prosecution failed to discharge this burden. Hence, petitioners must, perforce, be acquitted of the crime under Section 3, Paragraph E of Republic Act No. 3019.